It's Tuesday, June 30th, 2026, and this is Washington in Focus Daily. I'm Carlene Johnson. In today's episode, this was the final day of this term for the U.S. Supreme Court, and we had been waiting and anxiously watching for a decision that came down today concerning transgender athletes and the protection of girls in sports. We had that ruling, and we have exclusive reaction for you in today's episode with two young ladies who really became the face, the center of the argument here in Washington state um, to protect girls' sports, two young athletes. So, exclusive reaction with them just after that ruling this morning. Then, the Urban League of Metropolitan Seattle, under review by the Office of Washington Attorney General Nick Brown and the Department of Commerce regarding allegations of self dealing and the misuse of taxpayer funds, as well as federal probes that are underway, getting more money from the Department of Commerce for a big affordable housing project. We'll have some reaction to that. And then one of the big issues, of course, in this year's Washington Supreme Court contest is how the court is going to handle tax cases as a constitutional challenge to the state's new income tax moves forward. And in position 7, we have former King County Public Defender Kareem Merchant challenging Chief Justice Deborah Stevens. And the Center Square's Tim Clauser had an opportunity to interview Merchant and what he thinks about Chief Justice Stevens and what he suggests she may have gotten wrong in an exclusive interview coming up in today's episode. So we dive in. The U.S. Supreme Court this morning, I think it was 7:02 a.m., the first of the decisions they handed down today had to do with a ban of biological boys in girls' sports. And what the court upheld today in a 6-3 decision was that the states have a right to have bans on this, to protect girls in sports, to keep boys out of girls' bathrooms and locker rooms, and basically upholding Title IX protections. We have 21 states that currently have these laws in place to protect girls' sports, but Washington is among the remaining 23 states that allow biological boys to participate in girls' sports and use their bathrooms and their locker rooms. Now, Washington voters may well change that come November through an initiative on the ballot. So today's ruling and encouragement for those who want to protect girls' sports. But again, the whole issue is going to be ultimately decided by Washington voters in November. Now, you may recall, if you are a follower of this podcast and reader at our Center Square Washington page, you've probably seen stories, and on social media, they've been prominent. A couple of girls at the center of this fight here in the state of Washington. One of them is 17-year-old Frances Stott. She will be a senior at Tumwater High School this coming September, her final year in high school. And she refused to play couple of years ago in a basketball game. Girls basketball player, longtime player, since she was a little girl, but she refused to play when she saw that there was a biological male on the opposing team. And she said, I'm not going to play against him. He's a man, literally an 18-year-old man. And subsequently, she ended up being investigated by the Tumwater School District and the WIAA, Washington Interscholastic Activities Association. She was ultimately cleared of any wrongdoing, but they accused her of harassment and misgendering because she said, that's a man. I'm not playing against him. I'm a female entitled to do so. So I got reaction today from Frances just after that SCOTUS ruling came down.
So I think that it is a very great decision. I mean, I'm very happy that um, have been given that opportunity. I think it's really disappointing that it was a 6-3 voting, and the 3 people who voted no are women. So it is interesting to see them not standing up for other girls and women as well. I think that's disappointing. But I also think that although it is a win, it's not done in Washington. We still need people to vote yes in November. We still need people to protect the girls in Washington state because Jamie Peterson, Bob Ferguson, Chris Reichdahl, they will not. And so we need the people of Washington state to stand up and protect us girls because it is a very great accomplishment. It is something that we were praying for and hoping for, but it doesn't change anything in Washington as of now.
The other young lady at the center of this fight here in Washington state who has been so brave and courageous to speak up for protecting girls' sports is 16-year-old Annalie Wilson, a student at Eastmont High School in Wenatchee. Now, she lost a track meet when she was in 8th grade to a boy. She, stood on the podium and had to be knocked down, replaced up on the top by a biological male. Obviously, boys have testosterone and some, ability in sports and competition to be stronger, faster. We know that to be a biological fact. But she became very vocal as a young girl to speak out against this and said, "I think this is wrong." Um, I spoke with Annalie Wilson and her mom this morning, Elizabeth Wilson as well, just again after that ruling came down from the US Supreme Court.
We're just hoping that in November, Washington will be able to agree with this and that we can continue moving in the right direction. So, yeah.
Yes, and just going off what the girl said is that, yes, this is our step in the right direction. So we're going to take that win. And there is a lot of work to be done at the ballots. And that's on us as the adults who have the opportunity and the privilege to vote, to go to these ballots and to stand up and protect Title IX and protect our girls.
Now, Initiative 638, which is really IL-26, which stands for Initiative to the Legislature 26-638. Of course, the legislature declined to take these up, even though they're required by our state constitution to do so. So they automatically go to voters on the November ballot. This is an initiative backed by Let's Go Washington, and it seeks to require middle and high school students to compete based on their biological sex assignment at birth. So, barring biological male students from joining girls' sports teams. Now, the group No Hate in Washington State, their campaign manager, Libby Watson, emailed us here at the Center Square a statement following the ruling this morning. And it said in part this: Washington's blanket sports ban is the most extreme proposal of its kind in the country. Unlike the cases decided by the court today, it will require girls who wish to participate in sports to prove their sex through invasive genital examinations. Its impacts will not just be felt by trans girls, but by every girl in our state who wants to participate in K-12 athletics. That has been kind of the argument, and you're going to see it between now and the November election, basically saying, don't support this initiative because boys as well, will have to undergo invasive genital exams. That's what they say. But that really is not accurate. And it is informing people, wrongly before they decide such an important issue as this on the ballot. So Let's Go Washington sent me a statement in response to what the No Hate in Washington State group put out today. And that response statement said in part, the initiative does not state the girls will be subject to the exams that Hate in Washington State is so pathetically pushing. In the routine sports exam that already takes place between a doctor and a patient, the doctor and student athlete will decide which avenue to determine their biological gender makes most sense. That can be a verification of their previous medical records, a blood test, a history of knowing the patient, or whatever method the patient and doctor determine. Then a doctor checks a box, as doctors already do, on their existing medical form. Again, that's from Let's Go Washington in response to the claims coming from the No Hate in Washington State group, contending that there will be these invasive exams by doctors when that is actually not the case. And we also want to share a statement that we got today from Washington Attorney General Nick Brown, who posted this after the ruling this morning about transgender athletes, writing, "It's dismaying that the court would permit states to discriminate against trans student athletes. This ruling does not change Washington law, and we will continue to uphold the rights and dignity of trans youth." Now, I reached out to the Office of Superintendent of Public Instruction, Chris Rakedahl, early this morning, even before that ruling came out at 7 a.m., saying, I'm going to, be waiting for a statement. When my article goes up later today, that should be in time to provide that statement. But just ahead of recording this podcast today, OSPI said they were not ready to provide that statement just yet. But again, it's forthcoming, and I will share that in my article on our Center Square Washington page. So again, despite the ruling this morning from the U.S. Supreme Court, ultimately it's up to the states, and Washington voters will have the final say on this come November. So even as they are under state and federal investigation, the Seattle Urban League has secured another rather large bucket of funding for affordable housing. And we at the Center Square have been reporting on this controversy for much of the last year, and concerns about the use of Washington State's Community Reinvestment Program, CRP funds. It's a race-based program that was created to support home ownership and really lift up minority communities by providing these grants and funding for programs that assist low-income households, and to support, again, minority-owned business development as well. Well, the funds are administered by the Washington Department of Commerce and initially amounted to what was $200 million in taxpayer funds to lift up these communities that were disproportionately harmed by the war on drugs, they said, and housing discrimination policies of the past. So however you feel about these race-based loan and grant programs, the issue that we've been trying to bring some attention to for the last year are really whether or not there's some self-dealing going on within these programs. And Corey Orvold, a Tacoma real estate broker, has been the main whistleblower on this for the last year. And I caught up with her again this morning to kind of recap how all of this was initially exposed.
I volunteered with the Tacoma Urban League for 8.5 years, and my role was everything housing. So if a community member needed assistance, they'd call me. With that, it was well known in the community that I had that role. And so when Desiree Wilkins Finch became the new CEO, things started to change. And I saw the decline of an organization I deeply care about. And, after the conversation about her saying that, our hands aren't clean, I've been giving money to my friends in response to, the questioning of the Seattle Urban League and their practices around the Community Reinvestment Program and allocation of funds, I resigned. And once resigning, it really just opened the door to start researching. And when I started researching, that's when I started uncovering just the self-dealing, the self-enrichment, the cliquish, I'll help my friends, I'll help my family, but the rest of the community was SOL. It's really hard to see, even a year later that we're still picking up the pieces. I have people contacting me from the story saying, thank you for, helping, thank you for using your voice. How do I get assistance?
So again, this is back on our radar this week because the Washington Department of Commerce recently awarded millions to dozens of organizations for affordable housing projects, and the Seattle Urban League, despite being under investigation at the state and federal level for alleged self-dealing, received another $1.47 million. It is going to be for 36 affordable housing units that they are helping to construct. Now, this was part of what was called the 2026 Housing Preservation Program Awards, and it was nearly $40 million in all to 47 different multifamily affordable housing award recipients. it's supposed to construct or preserve more than 1,400 multifamily units with this funding. But again, the award for Seattle Urban League comes as the organization is under state and federal scrutiny. And the FBI has been meeting with the whistleblower, again, who resigned, as you just saw, from Tacoma Urban League after raising these issues and being told there's nothing to see here. She didn't want to be part of it anymore. She instead wanted to expose this alleged self dealing. So she shared again with me she's been meeting with federal officials. She has filed multiple complaints that have state scrutiny and federal scrutiny, and she's confident the people who may have, in her opinion, taken advantage of this and fraudulently, self-dealt taxpayer funds, she believes they're ultimately going to be held accountable.
This is a major scandal, right? The intelligence level of these people is not, this level of handling this level of corruption, right? I said it to TJ that, this is the American greed level of corruption with the skill level of going to Walmart and skipping some items in the self-checkout. These are not intelligent people. When they're getting called out, when things are being, pointed out of errors that they've made, documents are being re-recorded, scribbled out. Well, we didn't give 100,000, we gave 50,000. I mean, that's stupid. That's ridiculous that you're telling on yourself.
So I am preparing an article for Wednesday publication. I've reached out to Commerce, and we'll also be reaching out again to the Office of Attorney General Nick Brown to see what they have to say about the fact that Seattle Metropolitan Urban League is again receiving millions in taxpayer funds while under investigation for alleged self-dealing. So that'll come up in my article tomorrow, much more to come. And then finally, one of the big issues in this year's Washington Supreme Court races is how the court handles tax-related cases as a constitutional challenge to the state's new income tax as that moves forward toward the bench. It's going to be at least a year, maybe more. Voters may well actually have an initiative to consider as early as this fall's ballot. More to come on that later this week. But in position 7, we have former King County Public Defender Kareem Merchant challenging Chief Justice Deborah Stevens, who authored the court's majority opinion, Deborah Stevens did, in the case called Quinn v. State. And that was the 2023 ruling that upheld Washington's capital gains tax. Now, opponents argued the tax was an unconstitutional income tax, but the court ruled it was to be considered an excise tax and was not in conflict with our state constitution. Now, Merchant says that distinction matters a great deal because it increases the legislature's tax authority. And my colleague, Tim Clauser, specifically asked Merchant, candidate for that position, what he thinks the court and Chief Justice Stevens may have gotten wrong.
In State versus Quinn, the court upheld Washington's capital gains tax. You've referenced it a little bit by ruling it was an excise tax rather than an income tax, like the opponents had argued. What did you make of that ruling, and what, if anything, do you think that your opponent got wrong, or your opponent in the majority got wrong in that?
The legislature has complete discretion for excise taxes. They can tax that to the moon. They have the ability to tax, and there's nothing that can stop them from doing an excise tax, which is generally a tax on the benefit of being able to use something or on a transaction of some kind. So a great example of that is like we have the privilege of using a car. So they can tax anything to do with a car, whether it's gas, whether it's car tabs, they have the ability to do that. That's their prerogative, and that's completely within their constitutional authority. But they are incredibly limited on their ability to tax on property. And the Quinn decision determined that capital gains are not income. It's an excise tax. And you need to just step back and just reasonably think about this one concept. It's just basic business concept. When you are buying and selling, when I buy something for $2 and I turn around and sell it for $3, I have a $1 profit. I have a $1 gain. The Supreme Court is saying that that $1 gain is not income. The IRS sees it differently. And so that's the biggest point, that they said that that a capital gain is not income. Right? That blows me away just on the threshold matter of it, and just disregarding the fact of what the fact that the IRS thinks it doesn't matter what the IRS defines it as, it's what we define it as. And so that kind of took me back for a second. But then we start thinking about, is this an excise tax? And well, if it taxes the transaction, yeah, 100% it would be an excise tax. But guess what? It only taxes the transaction when there's a gain. It doesn't tax the transaction when you break even. It doesn't tax the transaction when there's a loss. So is that really an excise tax? And anytime, it takes like 52 pages to be able to explain that, you have to really go through and bury it. And it's just a lot to go through. You have to unpack it because it's trickery. I think that, it's 52 pages long to be able to explain why capital gains are not income, why property is not income. Sorry, why capital gains are not property. But then Justice Gordon MacLeod Justice Gordon MacLeod and Justice Johnson, who is retiring this year, in their dissent, the next 19 words, it's just so logical. And it just completely debunks everything that the Chief Justice had wrote in the previous 52 pages. And it's capital gains are income, incomes are property. Therefore, I knew I was going to blow the third line, but I'll let you guys read it and find out. But it flows logically, and I think the Supreme Court got that one wrong.
So again, we are less than 6 weeks from the August 4th primary here in the state of Washington, when the field of candidates for these Supreme Court races are going to be narrowed down to 2. We have a top 2 primary. That means regardless of any political affiliation for any position, the top 2 vote getters then advance on to the November general election. So that's it for today's episode of Washington in Focus Daily. It's the last day of the month, June 30th. We ring in July tomorrow, and I hope you will join us again on Wednesday. Have a great day.